Hi, I'm Michele Shuster, and I'm here with my colleague, Chad Blackham, and we're here with another week of Compliance Talk, and I am all about the Federal Trade Commission today. The FTC has been pretty busy over the last couple of weeks. We'll talk second about a non-compete consent order that they filed earlier this week. But what I wanted to start with is something that's interesting in that it's specifically targeted at StubHub. And what StubHub was doing is they were advertising prices online, but what they didn't do is they didn't disclose the service fee that was associated with that total price. So I'm sure most of you have gone through StubHub at one point or another in time, and you see this wonderful price online. You go to select those seats, you get to the checkout process, and then all of a sudden it's about $20, $30, $50 more than you thought it was going to be. So the FTC took issue with that, and the reason that they took issue with that is the FTC enforces a statute called Section 5 of the FTC Act, and in that it requires that all material terms of a sale with a consumer must be clearly and conspicuously disclosed. And so by hiding those service fees or additional fees that are tacked on at checkout, the FTC said they didn't meet that requirement. They were not being clear and conspicuous with price. Now, while that's a specific situation with StubHub, I'm sure there are a lot of other situations that could be relative to your business that involve additional fees being charged to a price. And it's just really critical that as you're advertising the price that you include or put the consumer on notice that there are additional fees that may apply. And if you know what those fees are, they should be disclosed to the consumer at the point of advertising. So it's a good reminder that the FTC is watching these types of things. It's also a good opportunity to realize that it's not just the Federal Trade Commission that looks at these types of things. It was that case with StubHub, but the state attorneys general have almost the exact same legal authority to pursue unfair or deceptive acts or practices, including not fairly and completely disclosing what the price is of something. So, good reminder.
So that's why I couldn't get reasonably priced tickets to the Eras Tour a couple of years ago.
I tried to go see Bob Dylan. He's coming to Columbus this weekend. And,
processing fees, handling fees, right?
It was a lot more than I thought it was going to be. So anyway.
Well, Michele, thank you for that. You are all about the FTC today. I'm all about privacy today. So we're doing a little bit of switcheroo from the usual. But a really important one for everybody and all the listeners. Alabama is officially set to establish and put into effect its own version of a privacy law. Alabama will become the 21st state to do so, joining Oklahoma this year as well. As I mentioned, becoming the 21st state to do so, adding to the ever-increasing patchwork, ad hoc nature of state privacy laws. Now, what's really interesting about Alabama's is the low threshold, however. So typically, in order to qualify for a privacy law, you have to service a certain number of customers, reach a certain revenue threshold, something to that effect. In order to qualify for the Alabama privacy law, you only need to process the data of 25,000 Alabama residents, which is the lowest threshold amongst any of the states and tied for the absolute lowest number. In addition, if you derive 25% of your revenue from the selling or sharing of data, even for non-Alabama residents, you qualify under the Alabama law. So it absolutely is something to be aware of, has some of the lowest privacy thresholds out of any of the state laws and may apply to you even if more extensive and burdensome ones such as California's do not. Now, there is a little bit of reprieve here. Thankfully, there's no private right of action, and only the Attorney General has enforcement authority for the time being. But amendments can change that. And speaking of the effects of amendments being able to change bills, the other item that I wanted to touch on briefly is some changes to Illinois' biometric security law. So for those of you who aren't aware, Illinois has passed one of the few states' different versions of a biometric security law. And what this relates to is things such as retina scans, fingerprint scans, temperature checks, which became really popular and prevalent during COVID with the forehead scanners. Now, what's really interesting about this case is that the court ultimately held that the changes to the Illinois law did in fact apply retroactively to limit defendants' liability. So, by way of specific example, the law provided a penalty for a violation of scanning someone's biometrics without their permission. But there's a big question, whether this was viewed on a per scan basis or whether it was viewed as, you did it to this person X number of times, that's one violation. The difference in liability for a company here could be massive. A per scan violation, $1,000 to $5,000 per violation, could be extraordinary. Significantly, however, in a case, a unanimous panel of the Seventh Circuit, so this is very significant, right below the Supreme Court, held in the case of Clay v. Union Pacific Railroad Co. that these amendments applied retroactively to limit defendants' liability under Illinois' biometric security law, BIPA, such that the defendants could only be sued on a total basis as opposed to a per scan basis. So what this means is that under the information law in Illinois, you cannot necessarily be sued on a per scan basis. This is good news for companies, but it's also a reminder that these laws are being actively enforced and litigated by plaintiffs. So while your exposure may not be as large as it was prior to the amendment, you don't want to count on that. You still want to review your policies and practices and procedures to make sure you're in compliance with all privacy laws, especially these new, more burdensome biometric laws.
Now, there'll be a lot of Illinois employers that are happy about this because a lot of these were brought by employees that were using biometrics to scan in and out of work, and employers are not getting consent for those. So, that becomes very pricey, especially if you have a disgruntled employee that's filing an employee action. It gives a lot of leverage to negotiations there to the employee. Speaking of employees, that's a great lead-in because the other action that the FTC has taken is that they have looked at the non-compete clause or contract provisions that a company, Rollins Inc., which is a pest control company under a bunch of different brands across the United States, was using for its employees. And the FTC filed a complaint and also at the same time filed a consent order, a proposed consent order with that. Meaning that they had worked to resolve this with Rollins. But the case is really worth understanding what was going on here because what the FTC took objection to was the fact that these non-competes were being applied to relatively what they would call the lower level employees and employees that were receiving lower income. So we're talking about like, customer service representatives, people who are answering the phones, technicians, folks like that. The issue was they were imposing a 2-year restriction after their employment stopped. So this was really a significant impediment to people leaving and getting a new job in the same industry. What made it worse is this is a nationwide company. They have over, I think it's 700 locations. So the chances of you being within the proximity where Rollins would be to a competitor are really, really good. So those employment non-competes are no longer going to be binding on the employees. One of the things that I want to stress here is when you're looking at your own non-competes, look at the level of employees that are being bound to these non-competes. Also look at the period of time. 2 years is a long time. Typically a non-compete is going to be 6 months to a year, and typically it's going to be a relatively small geographical area that the employee would be restricted from competing against the company. So make sure that yours are reasonable when it comes to those two types of things. Also, if you were to ask the FTC who they think non-competes should be used for, they're going to say it's those higher level of executives that have real decision-making authority and not these employees that are relatively lower wage with not that kind of authority within the company. I'll also remind you, though I'm talking about the FTC, states also have non-compete requirements and laws. So when you're talking to your employment attorney next time, make sure they review your non-competes, make sure they're in line with what the FTC is espousing here. It's a good thing to not to lose those non-competes for the employees that they really should apply to. So good reminder.
And one last final thing for us to note, as you may have seen, and we've talked a little bit about this, California has recently formed a new privacy protection agency for specific enforcement of their privacy laws and regulations. The agency did, in fact, confirm that they are all geared up, they're ready to go, and they will begin their audits and enforcement procedures this year. So for those of you subject to California's privacy laws, be aware and be prepared, because that's coming down the pipeline as well.
Good advice. Well, thanks for listening to us today.